are back, and we are joined by the always lovely friend of the show, Mark Joseph Stern, who is here to update us on the horror that is the Supreme Court. Although we do have some good news today. Mark, thanks so much for coming on the show.
Always a pleasure. Thanks so much for having me, Emma.
Sure. So let's start with the good. Like, we're going to do the good, the bad, the ugly here. Ketanji Brown Jackson flexed her muscle here as a public defender in this case, McElrath versus Georgia. That's exciting because, you know, she's obviously the first public defender to sit on the Supreme Court and one of the best Supreme Court picks over the past few decades, in my opinion. So what happened in this case, and why was her background as a public defender so central?
Yeah, this is such an interesting case. It involves both double jeopardy and the right to a jury trial, and came out of Georgia, where this guy tragically basically became schizophrenic, stabbed his adoptive mother to death. Everyone agrees that's what happened. He pleaded not guilty by reason of insanity. There were a couple of charges related to murder. On one of those charges, the jury found him not guilty by reason of insanity. On the other charge, the jury found him guilty, but insane. And under Georgia law, those are two different verdicts. One is an acquittal and one is a conviction. And so the Georgia courts looked at that and said, we don't think this guy can be insane and not insane at the same time. We don't think he can be guilty and not guilty at the same time. So we're going to throw out this verdict and we're going to allow him to be retried. There should be alarm bells going off.
Can I stop you there? Yeah, I just need, but they, I mean, he was deemed insane in both instances, right? So, but just the outcome was different. That seems to be, I don't understand why Georgia law set it up that way. I guess that's largely irrelevant, but they took it as an innocent plea on its face, or an innocent finding on its face, or a not guilty finding on its face.
Yeah, that's right. I mean, it's a weird way that Georgia law divides this. I mean, an acquittal is an acquittal, but if you're acquitted for being insane, you're sentenced to a mental hospital. If you're convicted but insane, you're sent to a prison. So there's an important distinction there. And the Georgia courts looked at it and basically said, you know, it can't be both at the same time. You're either guilty or you're acquitted, and overturned the convictions and allowed this guy to be retried on both of the charges, including the charge for malice murder, on which he was acquitted. And that is pretty much the definition of double jeopardy, right? The whole point of the double jeopardy principle is that you can't be retried when you've been acquitted. And the Georgia courts got around that by saying, well, we just don't think this verdict made sense. Basically, we don't think the jury knew what it was doing. It probably misunderstood the law. So we're just going to send this back and allow for a retrial, double jeopardy be damned. And that was what Justice Ketanji Brown Jackson took issue with and said, we absolutely cannot do this.
On its face, it seems clearly like a violation of the Fifth Amendment and the double jeopardy clause, essentially. She was able to, she wrote the majority opinion, if I'm not mistaken. And what was the outcome? I mean, how did the rest of the judges rule here?
Yeah, so she actually wrote a unanimous opinion, which kind of surprised me because I listened to oral arguments and it did not seem like it was going to lead to a unanimous outcome, but it did. We can assume that Chief Justice John Roberts assigned the opinion to Justice Jackson. And I think she really brought something to the table here because she was not only a former public defender, but an appellate public defender. And so she represented people who had already been convicted who were contesting their appeals. And so she brought a lot of insight into this always kind of murky question of why a jury does what it does. You know, there are a lot of reasons why a jury can vote to acquit. We're all told on like TV and in movies that the jury finds someone not guilty because they haven't had, you know, all of the facts proved beyond a reasonable doubt. But as Justice Jackson noted, and I think like she dealt with some of these cases in her practice, a jury can acquit for literally any reason or no reason at all. We talk sometimes about jury nullification. That is when a jury decides that, I just don't think that this is a just case, a just prosecution. We don't think the underlying conduct should be criminal. If a jury makes that call, a jury gets to acquit. If a jury doesn't like the way that the law shakes out, or doesn't even fully understand the way that a law shakes out, it can still vote to acquit. And no matter why the jury reaches that verdict, it is unreviewable by a higher court. It is a bedrock principle that a higher court simply cannot reject or review or overturn an acquittal. And it was interesting to me, the Georgia Supreme Court had unanimously just sort of refused to accept that. Georgia Supreme Court, a lot of former prosecutors, often has a kind of prosecutorial bias, didn't show a lot of respect for the jury and seemed to say, again, the jury didn't know what it was doing, so we're just going to send this back. Justice Jackson came in and she said, no. The jury knows what it's doing by definition. That is the whole point of double jeopardy. When a jury acquits, it has acquitted, and that is the end of the story. And so I think just beneath the surface of this case really is this issue of jury nullification. And Justice Jackson went out of her way to talk about how a jury can acquit for reasons of compassion, for reasons of lenity, because a jury just doesn't want a conviction for whatever reason. And that is really important to reaffirm because, juries are the one thing standing between somebody like this poor schizophrenic defendant and all of the might of the state. They're actually still pretty important, even though most cases don't go to a jury trial. And this was a very strong reaffirmation telling lower courts like the Georgia Supreme Court, don't mess around with this. Don't try to create these kind of technical end runs around double jeopardy. It's not going to stand by us.
Yeah, I mean, and it's interesting too because some of these conservative courts, they're more punitive, and I'm reminded of the Supreme Court's decision on the Voting Rights Act, where they've decided that it's in their purview to make determinations about what's in the minds and hearts of the people that are making these kinds of decisions. And so that in that instance, that was we were afraid, Congress was afraid of coming off as racist, and that's why they re-upped the Voting Rights Act, right?
Right.
So, I mean, so it's just incredible that these people who are textualists or identify as such spend so much of their time determining what's in the hearts and minds of those who pass these bills or laws.
That is a really good point. At least now we have a rule affirmed by Justice Jackson that you're not allowed to look into the hearts and minds of jurors. If they acquit, that's the end of the story. With the Voting Rights Act, it's a different case, but we'll deal with that later.
We can deal with that later.